Thank you. I'm rising further to the notice which I provided to the Chair under Standing Order 48 concerning the third and final report of the Special Joint Committee on the Declaration of Emergency, which was tabled in the House of Commons earlier today. In brief, on May 31st, 2022, the committee adopted an order for the production of several unredacted documents related to the government's declaration of a public order emergency in February of 2022, as well as the regulations and orders which were imposed in relation to it. The committee was particularly concerned with receiving and specifically ordered the production of a copy of the government's legal opinion for invoking the Emergencies Act. As outlined in the report, the then Deputy Minister of Justice and Deputy Attorney General of Canada wrote to the committee refusing to produce the legal opinion. While the material facts are outlined in the third report's Chapter 10, aptly titled Access to Information and Documents, I will recap the essential points for the benefit of those who aren't familiar with this particular saga, followed by citing pertinent authorities. In establishing the Special Joint Committee, the House conferred upon it, among other authorities, the power to send for persons, papers, and records. I would refer the Chair to subparagraph sub M, sub Roman numeral 2 of the motion adopted on March the 2nd, 2022, found at pages 471 to 473 and 480 to 484 of that day's journals. The Senate conferred the identical authority on the committee in subparagraph L, sub Roman numeral 2 of the motion, which it adopted on March the 3rd, 2022, as recorded in a message which this House received and published at pages 487 to 490 of the journals for that day. This being the first ever invocation of the Emergencies Act, the mandate to be pursued by the Parliamentary Review Committee required by law to be appointed was something to be settled. As mentioned in the 8th paragraph of Chapter 2 of the third report, the committee adopted a motion which, amongst other things, articulated the scope of the study it would initially pursue. The mandate included, quote, the options that the Government of Canada utilized during the invocation of the Emergencies Act, and in the, quote, study of each option, the necessity, implementation, and impact of that option, end of quote. Seized with the House's authority to compel the production of documents, the committee sought to do just that with a view to discharging the mandate which it had defined. As the committee explains in the 10th report of Chapter 10 of the third report, quote, the committee also learned that an internal federal government legal opinion had been drafted to determine whether invoking the Emergencies Act was justified under the circumstances, but the committee was unable to obtain a copy given that solicitor-client privilege was invoked, end of quote. We have since come to know, thanks to the Access to Information system, that it is a 10-page opinion and forms tab C of the Clerk of the Privy Council's February 14, 2022 memorandum to the Prime Minister to secure his formal approval for invoking the Emergencies Act. The committee elaborated on this matter later in Chapter 10, beginning with the 15th paragraph. Quote, it is worth noting that on May 31st, 2022, the committee adopted a motion that an order do issue for all security assessments and legal opinions which the government relied upon in determining that the various thresholds under the Emergencies Act had been met and that the temporary measures exercised under the Act were consistent with the Charter, end of quote. For the benefit of the Chair and the House, Madam Speaker, this is the full text of the order which the committee had adopted. Quote, that an order do issue for all security assessments and legal opinions which the government relied upon in determining that A, the threshold of threats to the security of Canada as defined by Section 2 of the Canadian Security Intelligence Service Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required by paragraphs 3 sub A or sub B of the Emergencies Act concerning a national emergency had been met. And C, the situation could not be effectively dealt with under any other law of Canada as required by Section 3 of the Emergencies Act. D, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4 sub 1 of the Department of Justice Act, and E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4 sub 1 of the Department of Justice Act, provided that F, these documents shall be deposited with the committee in both official languages within 1 month of the adoption of this order, end of quote. Referring back to the Special Joint Committee's third report, the 16th paragraph of Chapter 10 described what happened next. Quote, on or around June 29, 2022, a letter in response to the committee's document production order was sent by Francois Daigle of the Department of Justice, in which he writes that, quote, upon full consideration, it is our department's determination that all legal opinions in our holdings that would be responsive to the committee's orders are subject to solicitor-client privilege, end of quote. In his letter, he also states the following: although other countries may have occasionally departed from this rule, in Canada, it is solely within the discretion of the Government of Canada and its ministers to waive solicitor-client privilege in respect of legal advice provided to the Crown. For reasons of principle and practice, this rarely occurs, and the general rule remains that such advice will normally be withheld from committees of Parliament, subject to such ministerial discretion and consideration of public policy. It is worth mentioning that this letter sets out the grounds for refusal only as they pertain to information protected by solicitor-client privilege, but not by cabinet confidence, end of quote. Elsewhere in Mr. Daigle's letter, found on the committee's website, he wrote bluntly, and I quote, I confirm that I'm unable to produce legal opinions as sought in the committee's order, end of quote. Chapter 10 then recounts several other instances of the committee being stonewalled by government departments claiming various reasons for not complying with the May 31st, 2022 document production order. For the sake of brevity, I will jump ahead to the 29th paragraph, and I quote, "In the 2 years following the invocation of the Emergencies Act, the committee recalled some federal witnesses, particularly to obtain answers regarding its multiple requests for access to evidence, including the legal opinion the government relied on before resorting to the act. In February 2024, the current Minister of Justice reasserted the government's position that the legal advice in question was protected by solicitor-client privilege, which benefits the Government of Canada, the client in this case," end of quote. It is also worth mentioning that the 14th paragraph of Chapter 10, which notes the committee using a written questioning procedure which it deployed to gather evidence more efficiently, was further stonewalled by the then National Security and Intelligence Advisor to the Prime Minister, Jody Thomas, about the legal opinion. In December 28, 2022, she wrote to the committee, quote, "Due to solicitor-client privilege, I respectfully decline to answer this question," end of quote. That procedure is described in the Special Joint Committee's minutes for September 22nd, 2022, and again I quote, "that the committee send to each individual organization who appears as a witness written questions submitted by the members of the committee for response," end quote, and there follows a series of details about the procedure. Back to Chapter 10 of the third report, in the 32nd paragraph, the committee summed up its position, and this, Madam Speaker, is a critical point. Quote, "In light of the proceeding, the committee is concerned that it did not have access to all the information and all the documents that the federal government relied on to invoke the Emergencies Act and the related special temporary measures, in part due to the various types of privileges invoked by many of the witnesses," end of quote. In adopting its order on May 31st, 2022, the committee was exercising its authority, which is described at page 983 of the House of Commons Procedure and Practice, 3rd edition, as follows, quote, "The standing orders do not delimit the power to order the production of papers and records. The result is a broad, absolute power that on the surface appears to be without restriction. There is no limit on the types of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format, and that they are located in Canada. They can be papers originating from or in the possession of governments, or papers the authors or owners of which are from the private sector or civil society, such as individuals, associations, organizations, etc. In practice, standing committees may encounter situations where the authors of or officials responsible for papers refuse to provide them or are willing to provide them only after certain portions have been removed. Public servants and the ministers may sometimes invoke their obligations under certain legislation to justify their position. Companies may be reluctant to release papers which could jeopardize their industrial security or infringe upon their legal obligations, particularly with regard to the protection of personal information. Others have cited solicitor-client privilege in refusing to allow access to legal papers or notices. These types of situations have absolutely no bearing on the power of committees to order the production of papers and records. No statute or practice diminishes the fullness of that power rooted in House privileges unless there is an explicit legal provision to that effect, or unless the House adopts a specific resolution limiting that power. The House has never set a limit on its power to order the production of papers and records, end quote. This point was reiterated as recently as the Speaker's ruling on September 26, 2024, at page 25958 of the debates concerning Sustainable Development Technology Canada documents. Similarly, as noted in Erskine, May 25th edition, at paragraph 38.32, committees of the United Kingdom House of Commons exercise the same powers with the same unlimited scope. Quote, there is no restriction on the power of committees to require the production of papers by private bodies or individuals, provided that such papers are relevant to the committee's work as defined by its order of reference. Select committees have formally ordered papers to be produced by the chairman of a nationalized industry and a private society. Solicitors have been ordered to produce papers relating to a client, and a statutory regulator has been ordered to produce papers whose release was otherwise subject to statutory restriction. In recent years, there has been a very high-profile instance of the UK House of Commons insisting on the production of government legal opinions when, amidst the Brexit debates on November 13, 2018, it adopted a motion requiring the production of, quote, any legal advice in full, including that provided by the Attorney General on the proposed withdrawal agreement on the terms of the UK's departure from the European Union, including the Northern Ireland backstop and framework for a future relationship between the UK and the European Union, end of quote. On December 3rd, 2018, the Attorney General of England and Wales presented to Parliament a command paper which purported to describe the overall legal effect of the EU withdrawal agreement on November 25, 2018. On the same day he made a statement to the House, neither the command paper nor the statement made reference to the resolution of November 13, 2018, and the command paper did not purport to be a return to the resolution of the House. Later that day, after representatives of 5 opposition parties alleged the government had not produced the documents required, Mr. Speaker Burkow ruled that there was a prima facie contempt at column 625 of the official report. Subsequently, the UK House of Commons on December 4, 2018 adopted the following motion, quote, that this House finds ministers in contempt for their failure to comply with the requirements of the motion for return passed on November 13, 2018, to publish the final and full legal advice provided by the Attorney General to the Cabinet concerning the EU withdrawal agreement and the framework for the future relationship, and orders its immediate production, end of quote. In response, the UK government produced a complete, unredacted copy of the Attorney General's legal advice the very next day. The Attorney General later said that he had complied with the second order of the House, quote, out of respect of the House's constitutional position, end of quote, as reported at paragraph 68 of the UK House of Commons Procedure Committee's May 2019 report on the power to send for papers. A fuller description of these events was detailed in the question of privilege raised by the House Leader of the official opposition here in Canada on September 16, 2024, concerning Sustainable Development Technology Canada documents. And I adopt his comments for my own arguments for the proposition that the power to send for papers is superior to solicitor-client privilege. Our own Speaker Milliken held in his landmark decision on Afghan detainee documents on April 27, 2010, at page 2043 of the debates, quote, it is the view of the chair that accepting an unconditional authority of the executive to censor the information provided to Parliament would in fact jeopardize the very separation of powers that is purported to lie at the heart of our parliamentary system and the independence of its constituent parts. Furthermore, it risks diminishing the inherent privileges of the House and its members, which have been earned and must be safeguarded. As has been noted earlier, procedural authorities are categorical in repeatedly asserting the powers of the House in ordering the production of documents. No exceptions are made for any category of government documents, even those related to national security. Therefore, the chair must conclude that it is perfectly within the existing privileges of the House to order production of the documents in question, end of quote. We would do well to recall that the declaration of Emergency Committee's order concerned the legal opinion which was relied upon to justify the invocation of the Emergencies Act, a decision which allowed Cabinet to legislate without regard to the authority of Parliament or to the usual constitutional division of powers. In a March 9, 2011 ruling, Mr. Speaker Milliken cited page 281 of Sir John Burnow's Parliamentary Procedure and Practice in the Dominion of Canada, 4th edition, quote, but it must be remembered that under all circumstances, it is for the House to consider whether the reasons given for refusing the information are sufficient, the right of Parliament to obtain every possible information on public questions is undoubted, and the circumstances must be exceptional, and the reasons very cogent, when it cannot be once laid before the Houses," end of quote. From there, the chair added at page 8841 of the debates, quote, "It may be that valid reasons exist. That is not for the chair to judge. A committee empowered to investigate the matter might, but the chair is ill-equipped to do so. However, there is no doubt that in order to produce documents is not being fully complied with, and this is a serious matter that goes to the heart of the House's undoubted role in holding the government to account," end of quote. In the present case, Madam Speaker, the declaration of emergency committee has put this House, both Houses, actually on notice that, quote, "The committee is concerned that it did not have access to all the information and documents that the federal government relied on to invoke the Emergencies Act and the related special temporary measures," end of quote. Before concluding, I wish to address briefly Ms. Thomas's failure to answer the committee's written question. Page 1078 of Boss and Gagnon reminds us that, quote, "There are no specific rules governing the nature of questions which may be put to witnesses appearing before committees, beyond the general requirement of relevance to the issue before the committee. Witnesses must answer all question which the committee puts to them. If the committee agrees that the question be put to the witness is obliged to reply. The actions of a witness who refuses to answer questions may be reported to the House," end of quote. This is what has now happened here, Madam Speaker, and I would submit that it contributes to the overall concern about the government denying the Special Joint Committee the information which it sought. Finally, Madam Speaker, I will turn to the remedy which I would propose, namely to have the House order the production of the documents in question. This is, I would submit, a proper remedy in the present case. Firstly, Boston Gagnon discusses at page 138 and 987 the scenario where a committee report to the House on a case of disobedience to a document production order, which I note would be a contempt, may be addressed by the House adopting its own order for the production of documents. Indeed, the 2021 case involving the so-called Winnipeg lab documents saw this House, after its first production order was refused, order the President of the Public Health Agency of Canada attend the bar of the House for, among other things, the purpose of turning over the documents which had not been provided. This was, in turn, modeled on precedent cases which Boston Gagnon described at pages 131 and 132. In fact, the order paper is currently seized with a privilege motion concerning a similar remedy proposed in relation to Stephen Anderson, who did not turn over documents required by the Standing Committee on Access to Information, Privacy, and Ethics concerning the infamous so-called Other Randy. Moreover, Madam Speaker, I would submit that your own September 26, 2024 ruling on the Sustainable Development Technology Canada documents at page 959 of the debates speaks to the usual admissibility of such a motion when the defied order is of an ordinary character, like that which I would submit the Special Joint Committee had adopted. Quote, "The members who intervened on this question used words such as unusual, novel, and unprecedented to describe this particular production order. The chair agrees with those characterizations. It is indeed unusual, novel, and unprecedented for the House to order documents, not for its own purposes, but for a third party. Before insisting on the production of documents, as the opposition House leader proposes to do, the chair believes the House would benefit from having this matter studied further." End of quote. Unlike the SDTC documents order, Madam Speaker, there is nothing unusual about the order which the declaration of emergency committee had adopted yet failed to see realized. Therefore, I would respectfully submit that a motion to insist on the production of the documents is entirely admissible should you agree that there is a prima facie contempt. In conclusion, Madam Speaker, this NDP Liberal government gave itself sweeping authority to legislate in this place of Parliament and of the provinces and refused to come clean about the legal authority for doing so. Without straying too far into debate, the Rouleau Commission heard testimony that from the former CSIS director, David Vigneault, that the events of February 2022 did not meet the threshold that service must apply for threats to the security of Canada. The same threshold which Parliament said must be met before any public order emergency can be declared by the Cabinet. Yet Mr. Vigneault testified before the Commission that there was some special, magical, quote, separate interpretation of the threshold which he professionally applied day in and day out to justify the decision which the Prime Minister and his ministers were hell-bent on making. The fact that the Federal Court of Canada has since ruled that the government's actions in February 2022 were both illegal and unconstitutional only make it even more imperative, Madam Speaker, that there be full accountability and transparency for the Liberal Prime Minister's unilateral invocation of the sweeping legal powers which the Emergency Act conferred upon him. That's right. It is in this light, Madam Speaker, that I will refer you to page 141 of Derek Lee's The Power of Parliamentary Houses to Send for Persons, Papers and Records, concerning times when the House may need to compel the production of the Crown's law officers' work product. Quote, then UK Home Secretary Sir Robert Peel also acknowledged the power of the House in requiring the opinion of its legal officers. They stand in the situation of all other responsible servants of the Crown, and there can be no doubt that they are liable to have their opinion called for and their official acts revised where sufficient grounds exist in the opinion of the House for such a proceeding. An example of where the House might wish to require production, Sir Robert Peel said, if there was a suspicion that they, the law officers of the Crown, had acted under undue influence, an imputation against them of straining a point in favor of the Crown, the law officers would be justly liable to have their opinions called for and their official acts investigated. Similarly, Sir Robert Peel said, "I will suppose a case where the law officers gave a wrong opinion or where there was an opinion given against which the government acted. In either of those cases, I admit the House would be justified in calling for the production of the opinion," end of quote. That is why, Madam Speaker, the Special Joint Committee worked so vigorously to obtain a copy of the infamous legal opinion, and is also probably why the government has so steadfastly refused to shed any light on this matter. That is why I urge you, Madam Speaker, to find a prima facie case of privilege in the circumstances and to permit the House to vote on ordering the production of the government's legal opinion. Thank you very much, Madam Speaker.